All right. Thanks everyone that's already joined. I'm sure we'll get some people still joining in the next few minutes, but I think there's no need to wait any longer. We can get things kicked off. I see there's a gentleman here. Just a heads up, your camera is on in case you land up doing December shenanigans. I just want to give you a heads up. I know sometimes one is oblivious to the camera being on, but you're welcome to keep it on if you want to. All right, so my name is Albert Mouton. I'm a labor law attorney and I work as an organizer under SMIEO, the Employees Organization. For those of you that have joined this meeting, this webinar, who perhaps don't know much about SMIEO, aren't yet members, it stands for the Service and Manufacturing Industries Employees Organization, and essentially it's a trade union for employers, if you will. So it's an organization that assists with collective bargaining. We also assist, of course, with disciplinary matters, cases that go to CCMA or bargaining councils. We are the guys and ladies that go and represent you on the last front to actually get your case through and pass muster at CCMA to show it was both procedurally and substantively fair. So yeah, it's a pleasure being here today. If you like me, I'm sure at this time of the year you're also quite knackered and ready for a good break. If you're not taking time off during December, hopefully in January you'll have some time off. But it's a funny time of the year, you know, in terms of people being tired, emotions bubbling to the surfaces, Christmas parties, end of year functions. Of course, it's a time where people slip and drop the ball a little bit and transgress themselves and break rules. So this is a bit of a light-hearted webinar. We're going to look at some interesting case law just to, number one, have a bit of a laugh. There are some crazy stories out there, but of course it's a learning opportunity to also see exactly how we can protect ourselves, our companies, and of course protect our staff as well. Especially this time of year with Christmas parties, end of year functions, there are certain obligations on employers, for example, when alcohol is being provided. But without further ado, what I'll do is I'll quickly share my screen and then we can kick things off properly. All right, just bear with me. Okay, sharing my screen. There we go. All right, so as you saw on the invite, it's titled December Shenanigans. For those of you that might not know, shenanigans just means illicit or naughty behavior, things that people should not be doing. They get up to mischief and no good over this time of the year. So, of course, it's not a closed list. There's certainly more transgressions which occur over December. These are just some of the examples, interesting examples of common misconduct by employees over December. All right. Just want to change the screen. All right, so we've done our welcome and introduction. Some of the things we'll be discussing today is alcohol and resulting disrespect. I think this is one of the biggest issues over December, both in terms of workplace end of year functions, Christmas parties, but also people coming to work under the influence or bringing liquor to the workplace, etc. You know, even if it's offences committed off-site, but then they come to the employer's premises or the employer's client's premises and they aren't fit for duty, they're actually under the influence. Number two, we're going to just differentiate between annual shutdown versus annual leave. You know, most of us, I think, know the difference. However, the CCMA has erred on this and made, certainly in one case, an incorrect finding where they confused the two. And every company, of course, is different, but generally speaking, most companies I know do shut down for the most part. Most employees are off over December, over Christmas. But of course, depending on the sector and the sort of work, they might still have skeleton crew operating over the December break where everyone else is off. Physical altercations and offensive language and slurs. So this does overlap somewhat with alcohol and resulting disrespect, because alcohol can obviously result in physical brawls and offensive language and even racism. Another big one, sexual deviance in the workplace, again, often linked to alcohol and people getting too comfortable with one another, with their peers or even their superiors at work functions. So we'll touch base on that. And then the issue of bonuses and 13th checks. Is it a right? Is it an interest? Perhaps many of you have dealt with these before, but certainly this time of the year, there's a lot of uproar and issues over employees wanting these increases. Operationally, it's not always possible. But what happens when employees demand this as a right? Is it in fact a right? And we're going to look into that with a case example. And then at the end, I would love, if possible, to have a bit of a Q&A where we perhaps hear from some of you. Maybe you've got some interesting stories or anecdotes, interesting questions. Of course, every story, every case is unique and circumstantial, so there's not always a blanket answer to things, but perhaps I can be of assistance if you've got a specific question regarding shenanigans over December. All right, so let's get going with the first one, alcohol and resulting disrespect. So I found this case, which was quite an interesting one. It's from 2016. It's the Intraspeed SAPTY Ltd versus Boyce and others. And, as I've mentioned, we often have Christmas parties, end of year functions. And in this particular matter, the employee in question, Mr. Boyce, drank about 8 beers of 340 milliliters each at the workplace during the function. Fortunately, on site, nothing happened. There were no issues. However, when he returned home, he decided to have, I believe, a 9th beer. And big red flag, don't open up work emails, don't respond to work emails after you've had liquor. I think there was no onus on him to work at this time, but he chose to check his emails out. And obviously, in the state that he was, he did not make a good decision upon reading one of the messages. On his phone, he read an email from his manager or from one of the managers from Cape Town, the Cape Town branch, and verbatim, the email wrote or stated, "Why was this entry not cleared via GR as registered and instructed?" So obviously, he's somewhat lubricated from all the alcohol. He's not feeling too happy to read a message like this, which he obviously interpreted as being somewhat aggressive. And he then told his wife to send the following message in response, a very succinct, direct message, literally stating, "F you, thank you." So you can just imagine this didn't go down well. And I'm obviously, for the purpose of this webinar, omitting the full spelling of the word, the F word, but the actual email in response was the proper F word. And at first, strangely, the manager from Cape Town actually didn't take too much issue. I think he was a bit in shock and found it somewhat amusing. He shared this amongst other managers. However, after they digested what had actually happened, his peers told him, "You can't tolerate this sort of thing." And needless to say, disciplinary steps were taken against Mr. Boyce. So he was charged with gross misconduct in using abusive language to a fellow manager. It goes without saying, you can't say that sort of thing, even as a joke. He did plead guilty, but nonetheless, despite his guilty plea and his long tenure, he was dismissed by the chairperson. Now, importantly, in this scenario, this case, the chairperson said that he was already on a final written warning, and as a result of that final written warning, there was no choice but to dismiss him. But this became a bit of a bone of contention later on, because the final written warning was in no way related to the offense for which he was ultimately dismissed. And this is always in our matters when we assist members, one of the red flags. Yes, you may have a proliferation of issues and warnings on file, but please, there must be a nexus. There must be a connection to show that it's ongoing repeated behavior of the same sort. They are sometimes similar, and you can argue old warnings in relation to an offense, but in this particular case, there was no nexus, no connection. So feeling aggrieved, very unhappy with the outcome of dismissal, considering he had said sorry and pled guilty, he then approached the CCMA. The CCMA commissioner said that the dismissal was too harsh, substantively unfair. So of course, when you deal with CCMA, you have to show that your dismissal is procedurally fair, that you followed a fair process, they had a chance to hear the evidence against them, to state their case, to respond thereto. And also the evidence supports a guilty finding and the outcome is, of course, appropriate. In this case, the commissioner said it was substantively unfair. A dismissal was too harsh. So unhappy with this outcome, of course, the employer then took the case on review to the labor court. They did not want to accept that they could not dismiss this employee. And the court stated that the matter turns on a simple issue. Namely, was the commissioner unreasonable when he concluded that the sanction of dismissal was inappropriate and harsh? And for those of you that have not dealt with labor courts, it's not an appeal. We only go on review, and the test there is the decision one a reasonable commissioner would make? not a correct one in law, but a reasonable decision. The commissioner said verbatim in his award, and this was now assessed by the Labour Court on review, but the commissioner had said, given that the employee ought to have been treated as a first offender, now just bearing in mind that there was a warning, but the warning was irrelevant to the offence. And then he goes on, and having regard to the nature of the employee's misconduct, the remorse which was displayed by him and his length of service, I am of the view that the sanction of dismissal was shockingly inappropriate, excessive, and unfair. So what did the court have to say about this? The judge stated that, and again verbatim the judge's words, even if he, the commissioner, was wrong in concluding that the employee should have been treated as a first offender, because there was no warning for this sort of thing on record, such is not an error that renders his finding that the sanction was wholly inappropriate reviewable. In the whole, his award falls within the bounds of reasonableness. So ultimately, in essence, what the court is saying is, irrespective whether the warning was one relevant or not to the reason for which this individual was dismissed, ultimately a reasonable commissioner may, under the circumstances, find that dismissal is premature, that a warning should have been issued for this sort of thing. Now, this is very important because not every offence warrants a dismissal out the gate. Sometimes you of course need to consider the tenure, how long has the person worked for you, look at their record, is it blemished, do they have anything on their file, and of course a big question, do they show remorse? Remorse goes a long way. If the person in fact concedes that he or she was wrong, is apologetic, that is arguably grounds to rather issue a warning and not dismiss. So even if the judge would himself have come to a different decision in saying, well, actually dismissal is one of the reasonable outcomes, the point here is the judge's conclusion was that the commissioner's ruling that a warning should have been issued is also a reasonable outcome. All right, so this is a very interesting one. I can do a whole webinar just on remorse, on saying sorry, on similar warnings, etc., and length of service. Sometimes length of service can, of course, count against an employee where they should know better, but likewise, depending on the circumstances, it can be mitigating in that they've never transgressed previously and have been with you for a long time. All right, so I found that one quite interesting. Let's then move on to the next one. We'll come back to another example of alcohol later, but just to spice it up, let's now look at the differentiation between annual shutdown and annual leave. So in the case of Seerdal Group trading as Romatex Home Textiles versus Peterson and others, there was an employee dismissed for refusing to obey a lawful instruction, namely to work over the annual shutdown. So then the question comes up, can you force an employee to work over the shutdown? And the simple answer is it comes down to the agreement between the parties, whether a policy or a contractual agreement, even a verbal agreement, if you can prove that verbal oral agreement. So in this case, it was common cause that most employees took their annual leave during the shutdown period. However, this was not the case for maintenance workers, as they had to perform maintenance work during the shutdown period while production is not ongoing. So obviously, it's a quiet time of the year. It's a good time to get this sort of work done. Such employees could, however, take their leave at other times during the year. So it's not to say they don't have any leave just because their colleagues are on annual shutdown leave. They just have their leave later during the year or even earlier during the year. So this particular employee actually demanded more remuneration, an increase to work over the shutdown period. He was dismissed for failing to follow a lawful, reasonable instruction, and inevitably the matter landed up at the CCMA, where he said he was unfairly dismissed. So in this case, the CCMA commissioner found that work during the shutdown period was illegal in terms of the Basic Conditions of Employment Act and the main agreements of the Bargaining Council for the Clothing Manufacturing Industry. So, often the commissioners get it wrong. And once again, in this case, it went beyond the CCMA. It went to labor courts. But on that basis, the commissioner found that the dismissal was substantively unfair and ordered the applicant, the employer, to reinstate him retrospectively to date of dismissal. So to put him back in his job with back pay from the date from which he was dismissed or on which he was dismissed. The employer, as I mentioned, went to the Labour Court on review to challenge this, saying it's unreasonable as an outcome, as an award. And the judge considered the following. He looked at Section 20, subsection 9 of the Basic Conditions of Employment Act, which states verbatim that an employer may not require or permit an employee to work for the employer during any period of annual leave. He also looked at Clause 21.9 of the main agreement of the Council, which repeats the section verbatim, so it's just a copy-paste from the Act. And the main agreement goes no further. It's silent on any explanation as to when the annual shutdown would be in relation to annual leave. So there's nothing, there was nothing before the judge stating that by contract or by legislation or collective agreement that there's any obligation on the employee to work concurrently with his annual leave. So there's no contractual provision whatsoever that annual leave must be taken at the time of the annual shutdown or that they overlap. Ultimately, the judge said, in this case, the commissioner has misdirected himself in equating the applicant's annual shutdown period with a period of annual leave. So simply put, you can't now call these two different things the same thing. There's nothing to show in terms of evidence that the individual would lose his leave, his annual leave, and nothing to state that it would be concurrent with the time of annual shutdown where everyone's off, and now he must be the exception to the rule that he must work and lose and forfeit his leave. So the judge said, the commissioner's misdirection goes to the heart of his award. It is so unreasonable that no reasonable commissioner could have come to the same conclusion. It must be reviewed and set aside. Ultimately, the judge also put a ruling in. He didn't refer the case back to CCMA and actually himself ruled that the sanction of dismissal for failing to follow an instruction was in fact fair. So I think how do we take this case and apply it back to ourselves? I think it's very important for our members to just go and have a look at their policies, their contracts, just ensure that everything is above board, that there's nothing where we erroneously by accident overlap annual shutdown with annual leave. I think it goes without saying that you can't take someone's leave away from them. But where you do require skeleton staff, skeleton crew to work or do upkeep or maintenance during a quieter time like shutdown during the year, we should codify this. We should put this in writing, preferably from the onset in contracts, in policies which are binding on staff, and explain it to them if there's any ambiguity or confusion by employees. All right, so I'm personally of the view this one's rather obvious, which is all the more surprising that a commissioner actually found that the company had been unfair. Right, so we can now move on to physical altercations and offensive language or slurs. Very interesting case here, Saktu versus HC Lee Co. Pty. It's a CCMA case. And once again, it relates to an end-of-year Christmas party. So I am mindful most of the Christmas parties have already wrapped up for this year. If you don't still have your Christmas party coming up, you can certainly apply this knowledge and these stories to next year just to cover yourselves. Or perhaps incidents did occur already this year, and you can look at this for assistance and also contact us for us to assist you on how to deal with any misconduct which occurred at the workplace or at a company event. But in this particular matter, it was a massive end-of-year Christmas party with 300 employees, which you can just imagine the bill there, the tab, must have been humongous. And needless to say, there was liquor involved. So some employees did get into a physical altercation. I won't go too much into the detail, but one of the issues arose because someone accused a fellow employee of attaching a condom to the back of his pants or his shirt or something to that effect. So people are not thinking straight. They're making all sorts of wild accusations or reacting to wild pranks. The point is that a physical altercation did ensue. And eventually one of the directors tried to calm people down, removed one of the employees involved from this party, just to calm him down, to obviously diffuse the situation. That individual's brother, who was also there, then took great exception to this. When he was called to come assist to actually help calm this brother down, he actually started aggravating the situation, making it worse by demanding his brother be allowed back to the party, back to the end of year function. and he got rather boisterous, rude, and used vulgar, obscene, racist behavior or language. He actually went so far as to call this director, who was holding his brother back from going back to the party, he called him an effing white pig. Once again, I've just omitted the words. I don't want to offend anyone here, but at the same time, obviously, this goes to the heart of the reasons why these people were dismissed. So I do want to specify what actually happened. So I think, once again, needless to say, you can't call someone an effing white pig. It's obviously something that warrants dismissal. And one of the questions which arose in relation to this was, and this is just more of a side issue, but does a company have rights to discipline staff where it's not on the work premises, it's not per se work related? What happens on that? Can a company actually deal with these sorts of incidents where someone is using this sort of vulgar language and being most disrespectful? In this matter, the union argued that the misbehavior only occurred because the employer had provided the alcohol to staff. So, trying to argue that, if nothing else, as a mitigating factor, the employer had created the situation which it now faced, in that it fueled the issue by giving alcohol and, to some extent put fuel in the fire. Arguably, of course, the whole thing wouldn't have occurred whatsoever if not for the alcohol. But, can a company then take action in relation to this? So the company's argument was that the staff were still being paid for the day. It had the right to remove employees, and their behavior was still within the confines of the work relationship. Obviously, the staff would not be there if not for the company nexus or connection. It was a year-end function. They may not have been working, but it was in relation to their company, and the offences did affect superiors within the company. I think it's a bit obvious, but the CCMA argued dismissal is fair. Now, although that might be obvious that you can't act in this manner, I thought it was an interesting case just to confirm that as long as there's a connection, a nexus back to your employer, you can always take action and discipline someone, even if it's off-site misconduct unrelated to superiors. Maybe someone is rude to another company representative, but it's on social media. There's a video of this offense, and that person has the company logo. Likewise, there you can connect it back to the company and take action and even dismiss. But certainly in the case at hand, despite being the ones that provided the liquor to staff, they could still take action against their employees for transgressions. We're talking about adults here. They should be able to control themselves. They should be able to handle their liquor, or at least cut themselves off before creating incidents like this. And I think we'll deal with this shortly in Q&A, but the question often comes up, should it be an open bar? Should we have a limit on alcohol? And I think we can ventilate that issue later on once we get to Q&A. Because a company can certainly, from its side, mitigate these risks arising, or prevent these risks from coming up, these incidents from arising. All right, so sexual deviance in the workplace. You can imagine this also comes up quite often. We often hear about these sorts of incidents in the workplace throughout the year, but again, during December, something just seems to rile employees up and cause more transgressions, particularly at that time of the year. So this is a very old case from 1999. It's a CCMA matter. And once again, it was an end-of-year function. In this case, the court found that the employee in question, who had resigned, had in fact, or may have in fact, have flashed her bra at fellow employees. And this now goes to how a company reacts to incidents in the workplace. Now, bear in mind, this is 1999. Things are more onerous on employers now in terms of new codes of conduct, new policies, harassment policies in the workplace. So the manner in which the company reacts to this incident is obviously unacceptable. And in today's climate, and with the current legislation and policies in place, it's even more onerous on employers to take action in similar circumstances. So in this matter, it's believed she may have flashed her bra, but this does not justify what happened thereafter. Fellow employees, men, I presume, then removed her shirt, went as far as to fondle her, and tried to remove her shorts. And it was a big joke. The whole claim was, no, well, you started it. We're just having a joke. We're having a laugh. So needless to say, this individual, Ms. Payton, despite having to some extent provoked the sexual harassment. Despite that, it was still not acceptable behavior, and she took issue with this and reported this to the company. The colleagues were, of course, not justified in doing what they did, and it did constitute serious assault and was not a mere joke as claimed by them. The problem lay in the fact that when she reported the incident, the employer failed to take it seriously, failed to properly investigate it, laughed it off, and just in a holistic sense, failed to deal with the matter. So she then resigned, claiming constructive dismissal in that it's an intolerable work environment, and she went to the CCMA and won herself 12 months salary. So again, a lot of these cases might seem obvious to you. I might be preaching to the choir that you should act accordingly and take action in relation to these sorts of offenses and investigate them, and if need be, suspend certain individual pending the outcome of the investigation. But yeah, for those of you that don't know much about this, there's a huge onus obligation on the employer to take action and investigate. And as you can see in this case, she got 12 salary. All right, we are moving quite quickly. I want to get to the point where we can open up the floor and have a bit of a Q&A. I don't want to just yap on and hear my own voice the whole time. So we've now reached the last topic here, last case analysis. It's regarding bonuses and 13th checks. Are they a right? Are they an interest? Well, it really all depends on the context. Once again, it comes down to the law of contract. What is in your contracts, your policies? Is there something guaranteed to them? Can they, from their side, argue some sort of right or reasonable expectation that they should, in fact, receive a bonus or 13th check? Depends on the wording. If there is something pertaining to bonuses and 13th checks, have you got it worded to say it's discretionary in relation to performance, misconduct records, economic climate, etc., etc. So please, you are welcome to contact us just to vet your clauses in this regard. If we haven't already done a contract for you with a clause on this, we can vet what you have. We can certainly assist to draft something appropriate. Because the big contention is it an interest or is it a right? I've personally this year dealt with a case where SMIEO won a case for a client, for a member, where the argument was that there was a reasonable expectation. It wasn't codified in writing, but there was a reasonable expectation to a bonus. Our argument was that, yes, our member may have given bonuses in the past, but it has always remained discretionary. And in the matter at hand, the individual demanding or claiming the bonus as a benefit, as an unfair labor practice claim in that it was not paid, this individual had transgressed. She had not acted promptly. There was damages to a client. They lost a client. And on that basis, they did not give this discretionary bonus. So employees often refer an unfair labor practice claim saying they have a right to this benefit of a bonus, but where they have no such right, they cannot prove there's a reasonable expectation of getting the bonus, there's no contractual clause on that stating they will get it, etc., then it does become a matter of mutual interest. So the case before us, the UIS Analytical Services versus Independent Democratic Union of South Africa and others case from 2025, I won't go into all the details here, but this case also commented on this distinction between interest and right disputes. Essentially, employees have no contractual right to bonuses. They equally have no right to the bonuses under any of the employer's policies. So in this case, they had no right to it, despite trying to argue there was a benefit, a right to actually getting the bonus, similar to the example I just gave. And ultimately, the fact that a bonus would qualify as a benefit by definition, which is an unfair labor practice claim if they want to try and enforce the benefit, this does not in and of itself mean that they have a right or entitlement without that contractual right. That right must still be in terms of contract or policy. Where no such right to a benefit exists, the demand for such a benefit is an interest issue, a mutual interest issue, which can only be pursued by collective bargaining, followed by industrial action if unresolved. So I know it's a lot of big words, but perhaps you've dealt with this before. Simply put, should you not be amenable, not be willing to agree to give bonuses or 13th checks, which are not a right according to you, then employees have a right to go strike after following due process, where they refer a dispute to the CCMA for conciliation, try to come to some sort of arrangement to agree on these issues, failing which then they get a certificate, they have to finalize picketing rules, and they have the right to lawfully strike. So there's a bit of dotting the I's and crossing the T's before they can have a lawful strike. And if it's an unlawful strike, you can take disciplinary action. But this is the big difference. If they have no right to a bonus, they can strike until you concede and give them what they want, or perhaps they give up on the issue and come back to work. In the interim, you may very well be able to hire scab labor, replacement labor, pending the finalization of the strike. But again, there's no right in this example. If they have a right that they want to enforce a contract, they do in fact have to go argue at arbitration for unfair labor practice. All right, so I know it's been quite a mouthful. I've gone quite quickly through these different cases. I did find them quite entertaining, quite interesting. I would love to now open the floor to both answer questions, maybe hear some anecdotes, hear some stories from members, maybe past experiences, maybe something from 2025, maybe, you know, questions on how to draft policies, etc., going forward for 2026. And this is not a closed list. I've just canvassed some interesting stories in cases about December shenanigans. Certainly, absenteeism is a big problem over this time of the year as well. So yeah, let me just open up the floor and have a drink of water. I've been going on quite a bit here. And please, if you've got any questions, you're welcome to put your mic on. Otherwise, you can type something in the Q&A. Thanks so much. Let me just open the chat. All right, I think we've got robots taking over here. I see there's a lot of AI recordings. Just want to have a look here. All right, I'm not seeing any questions as yet in the meeting chat. Just want to have a look here under Q&A. All right, so there's no questions typed out as yet, but please don't be shy. If you've got anything to ask me, now is your opportunity. Otherwise, at the end, you are also welcome to contact me. I will share my email address if you've got something more private you want to discuss, something to canvass with me. But as mentioned, today was just a bit of a somewhat light-hearted discussion and analysis of case law. And yeah, if there's no questions, of course, then we can finalize proceedings. I'll share my email, and if there's a more private matter, you can email me. But now is your chance. All right, Devine, thank you, Devine. I see you say thank you, Albert. All right, guys, I'm going to share my. Let me just open this message. Hang on a second. I think I see some messages coming through. All right, Devine says thank you. Trudy Boeta says thank you so much. What about the trust that one should have in your employees? Would that not supersede the drinking? Yeah, I mean, thank you for that question, Trudy. I think it's very circumstantial. I think it of course depends on all the facts of the case. Every case is unique. These cases are not blanket cover. They do not cover every single situation and all circumstances. I think devil's advocate, the argument could be made that, you know, to some extent they're incapacitated. They've been given the liquor by the company. Maybe they are not in control of all their you know, not in control of themselves. And some leeway and forgiveness should be provided on that. I'm not saying that's a blanket cover excuse. Obviously, they're also adults. They shouldn't get drunk. It is circumstantial. Your question, what about the trust that one should have in employees? Would that not supersede the drinking? I think, yeah, I think generally speaking, we would obviously make the argument that they are adults. They should control their intake of alcohol. It does not necessarily justify what they've done, their actions. But again, if their argument is, listen, I was incapacitated, I just overdid it, it could be mitigating. If they show remorse, it could be mitigating. It does depend on how they react. If they've got no remorse, if they almost maintain their statement after sobering up, then of course that's a no-brainer. We can take action on that. So yeah, it's difficult to give a blanket cover answer to that one. I see Pierre. Thank you, Pierre. You said well presented. Cheers. Sean House, thank you. So yeah, that seems to be all the questions. I just want to thank everyone. I know it was a bit of a short and sweet one. As mentioned, it was just a bit of a light-hearted end to the year. We will have one around middle January 2026. I believe the topic will be in relation to retirement policies, the do's and don'ts, and what happens if you don't have a retirement age in your contracts or policies, how to handle those employees. We can, of course, also assist in implementing them. We're going to look at some very important case law that came out in the last year or two, constitutional court judgment, which said, well, I won't go into all of it, but a very important court judgment which did comment on how to deal with employees that have passed the retirement age, even if you have a clause with a retirement age. Maybe they've gone to age 66 and your clause is 65. Can you still end employment after they've passed that date? There's a bit of a gray area in terms of the Concord judgment, so we will canvass that in January, but in due course, we will send an invite for that. I see there's another question, I think. Hi, Albert. Thank you for the presentation. How does one deal with habitual absenteeism where employees absent themselves on a Monday, more typically in December? All right. So, we always advise members to look holistically, to zoom out and look, is there a trend of Fridays and Mondays? It becomes quite apparent when they're abusing the Friday, Monday to get a long weekend. And again, it's always down to argument. If there's a trend, it's certainly easier to motivate a dismissal. What we don't advertise too much is the fact that in terms of the Basic Conditions of Employment Act, irrespective of what your policies and clauses might say, an employee is entitled in an 8-week period to 2 days without submitting a doctor's note. So if in that 8-week period there's a Friday and a Monday where they haven't got a doctor's note, technically you can't take issue for those particular 2 days that they haven't got a doctor's note. But thereafter, certainly if there's a trend in that 8-week period onward of Mondays and Fridays or both, then you can insist on doctor's notes. And if it's habitual, you can certainly also, in my mind, take action and have an inquiry and investigate issues a bit. It is unfortunate, especially over December, they do abuse this. A doctor's note, if legitimate, it is binding on parties, or it is legally, it should be accepted. But again, we need to look holistically. Is it someone that is habitually doing this? Then you can pinpoint, listen, this is a troublemaker. It's worth investigating. It's worth putting through an inquiry. Let the chairperson assess the facts. You never know what comes out. Maybe there's a plea of guilty, or evidence does support a case for dishonesty and dismissal. All right. I see that. Thank you in our family. I see there's a thank you from you. And then at the bottom, there's a question. Just to elaborate, the BCEA states that employees can take 2 days of sick leave in an 8-week period. Yeah, that's exactly what I was just saying. Brilliant. Without producing a sick note. Therefore, we battle as a company with employees absenteeing themselves on Mondays and claiming illness. Yeah, 100%. So that's exactly what I was commenting on now. I see that Davine also says she agrees. If there's a medical condition, the employer should be informed. That's another way to go. Of course, if you're looking holistically that there's this ongoing absenteeism, you could very well, in terms of your own contract, take them, in terms of that agreement in your contract, take them for medical analysis and investigation with your own doctor. That's a way to go, to say, we want our own reports. What is the issue here? You are habitually late. There's a fine line between what is private doctor-patient confidentiality, but there comes a point where a company can say, listen, we need to understand why you are absent so frequently. This could very well become an incapacity due to illness. Again, very contextual, depends on the case. It's not a blanket cover answer for everyone, but that's one way to go. So thanks for that, Davine, and to the other viewer also mentioning the basic conditions and the 8-week period. All right, guys. I'm going to give it just 1 more minute in case there's any other questions. In the meantime, I'm going to share my email. If you've got any private questions you want to send to me, again, we can have a look at your policies. We can have a look at your contracts just to make sure it's all above board and does pass muster. If it goes to CCMA, let me just share my email with you. Second. Oh goodness, sorry. Difficulties. 1 moment. All right, there we go. All right, you should see my screen now. All right, so there is my email address. It's amouton, AMOUTON, at SMIEO, SMIEO.co.za. You are welcome to contact me. for any queries you may have, and we can get back to you on that. And yeah, I just want to say thank you very much. Let me just show my email again. Sorry for that. So it's amouton@smio.co.za. Just want to thank everyone again for being part of today. Really appreciate your time. I know it's a bit of a crazy end of year time. It was lovely having so many viewers actually attend this webinar, considering most people are lying on the beach with their feet up. All right. Thanks, everyone. God bless and have a wonderful Christmas. Cheers.